The first session, we have 4 speakers, and I invite all the 4 speakers to come on dais. SS Mittal Code, Ex-DJM of Karnataka Appellate Tribunal, Bangalore. Please come on. We have the second speaker, Sudhir Krishnaswamy from Azim Premji University. Please come on dais. We have Pratik from National Institute of Public Finance and Policy, New Delhi. Please come, Pratik. And the fourth speaker is Surya Prakash, Daksh, India, Bangalore. I request each speaker to stick to the time of 15 minutes. And to begin with, I invite SS Mittal, sir, please.
Good morning, everybody. All my co-panelists and all the dignitaries and invitees. The subject today, state welcome subject today is the access to justice is theme and the role of the tribunals and importance of tribunals. They say that the quantitative, since with my experience as the DJM of Karnataka Appellate Tribunal, not only quantitative but qualitative work is also done. How I will tell you. My first opinion is the tribunals are not just alternative, but they are the best alternative for the common man to get easy justice, speedy justice, and little the procedural hurdles. So when I took up this membership as a tribunal member in July 2009, I did little know that it was the very good institution where I joined. After 2 months, when I started disposal of the matters, particularly Karnataka Appellate Tribunal, I was given the tax bench. Friends, the tax bench for the district judges is a challenge because we never studied CA. I am not a BCom graduate, but I am very happy to tell you that for 2.5 years, the chairman did not change me from that bench. Because with the cooperation of the department member, I was able to do the best, and my department members were telling me that, no sir, we have to learn a lot. So after 2 rounds of the department litigation, the tax benches, that means one assessing officer, another is first appellate authority. The appellate tribunal, though it is second appellate authority, but it's not second appellate authority, it is first appellate authority. The 2 rounds of government litigation, department litigations, I considered it as one. How the quality work was done, I want to quote from my experience. It was the tax matter relating to IBM that I have written that judgment. Whether ERP service, Entrepreneurial Resource Planning Service, involves any transfer of goods or not. That was the issue. See, my department members were telling me that, no sir, we are interested in revenue. First I told them, here you are not the department member. You are the presiding officer of the tribunal. You must see that whether the recovery is according to law or not. You are not sitting here to protect the revenue or damage the revenue. Then with their help, I said, no, you give me the facts. I will put it in the frame of law. Because the matter, it goes to the High Court. The High Court will definitely look into the aspect of the district judge, what he has done in the first appellate authority. Therefore, with their cooperation, what happened in that case, every time they were writing the judgment in favor of the revenue. Then I told that even if I remand it to the first appellate authority, again back the same will come. Then I wanted to put an end to this. How? As a first appellate authority, we had the provision for taking evidence on this point. The lower courts have not taken any evidence on this point. And I told them, requested both sides, please provide evidence, because this is a technical aspect. Enterprises resource planning say technical. So please provide evidence on this. We will take evidence in the tribunal and we will decide it. See, after taking evidence, both agreed, and after taking evidence from both sides, I wrote the judgment and held that in ERP service, no transfer of goods takes place, but there may be service tax component. And that judgment was upheld by our Honorable High Court in Sasken's case. And recently, where I was practicing Dharwad bench of Karnataka, some tax lawyers met me and told me that this judgment is also upheld by the Honorable Apex Court in another case. So this is, I say, qualitative, not only quantitative, qualitative. Therefore, the role of the tribunals is most important. And another point I want to tell you, one matter was pending in Karnataka Appellate Tribunal for about 4 decades. 4 decades. That was the matter relating to the grant of land under Hyderabad Inam Abolition Act. See, it's so if the litigant is lucky, that matter comes before me. In the November 2011, what happened? The sitting was at Gulbarga. My friend, District Judge member, expressed that he is unable to go there. Then I said, I am ready to go. I went there. There are very few cases. It was the 1948 application filed by that poor litigant. Then I was shocked. What is this? You people say that there is a delay in courts. This tribunal is said to be very speedy way of justice. How it is? Then I heard that matter. What happened? There were 11 big bundles of the records. 11 big bundles of the records. Everybody is telling, no sir, this is heavy matter. No, I think that matter is not heavy. We have made it heavy by adding unnecessary files. I came back. I personally verified. Do you know, sir? The matter was 2 villages of Bidar district, Gullar Haveli and Aliyabad. I remember those facts very clearly. One survey number which he has applied for was whether this belongs to Aliyabad or Gullar Haveli. The proper person to speak about that is Deputy Director of Land Records. Deputy Director of Land Records has given clear-cut finding that this belongs to Gullar Haveli. There's nothing to do with the other village. Though merger has taken place, this has nothing to do with the applicant is entitled for this. But however, the revenue people were not ready to give it to him. When it went back to the Deputy Commissioner, he again dismissed it. Again it came to the Karnataka High Court, this MRAT, Karnataka High Court. Again it goes back. In this way, it has taken rounds from High Court, KAT to Bidar to KAT. Then ultimately, I have call out everything, wrote a judgment, and said that the series of this litigation is like a TV serial. Episodes are dragged from one to another and made to languish in this. I wrote it and strictures passed and sent it to the concerned secretary. After 1.5 years, when I left the tribunal, the revenue representative told me that, sir, your order is complied. 50 years after the order is complied. This is the result of the tribunal. So tribunals are not just alternative, but the best alternative for the speedy justice to the people. And it's my opinion that the chairman and the registrars play an important role in effective administration of tribunal. Now I am told that the present chairman of the KAT and registrars are very much interested in enhancing the quality of this work. I wished I should have been here at this juncture. But anyhow, sir, see, this is not just but best alternative. And I had 2 interactive sessions with my staff there as to how administratively we can take the benefit of. Adjudication matter is done by the district judge and department members. But administrative matter, if the order doesn't reach the person, again there is a problem. I had 2 interactive sessions with them. So they are all cooperative, and more so the staff, if we train them, they will be of much assistance to us. Particularly in appellate tribunal, I have never faced any problem from the advocates here. They were ready to argue with the matters. The other one matter, it was relating to the service conditions of the Cooperative Milk Union, Kolar. See, in the last 6 months, I have posted to this cooperation bench. There, a matter which was languishing for 10 years. See, we see that when our DA is not given, we are much bothered. When our increment is not given, we are much bothered. Those people were struggling hard for 10 years to get the relief. When I was transferred to that bench, I took up that matter in 2012 when it was filed in 2002. And I decided the matter. Therefore, of course, the delay is because of other reasons, I know, but the justice was done. Last, giving one example, I conclude my speech. The problems, this tribunal has got an important role as a fact-finding body. When I was sitting in the cooperative bench, I was shocked to see a judgment of the arbitrator. I don't call it a judgment. It's an order. That man has written in such a fashion. The person who has come before me was left with no alternative except to hang himself. Do you know that what has happened? He has applied for the loan of 28 lakh rupees to the cooperative bank. There was a delay for purchasing the house. There was a delay in sanctioning the loan. What happened? That poor fellow, owner said, if you don't purchase it, I will sell it to others. So that poor fellow arranged the funds elsewhere, purchased the house. And this bank sanctioned the loan, and to whom it should be given? It should be given to the person who has applied for. No, they have given it to the person who has sold the house. This man has taken 28 lakh rupees from this poor man, and 28 lakh rupees from bank, 6 lakh rupees ran away. See, he says that you have sanctioned loan but not given to me. He went before the arbitrator. Arbitrator never applied his mind. No, it is sanctioned to you, but if mere sanction is one thing, giving it to the loan is another thing. He gave, you pay this 28 lakh rupees principal, 28 lakh rupees interest. 56 lakh rupees award passed him. I remember that it was 2012, March 22nd. March 28 is the day on which the auction of the house of that poor man at no fault of his was fixed. I heard that matter on 22nd, passed the order on 25th of March and set aside the judgment with the strictures saying that this is gross injustice done by the arbitrator. That auction was postponed, and later the department officers told me that we had taken action against that bank. Yes, that is why, sir, these are not just alternative, best alternative and the best decision of the government, and they have taken much burden of the High Court. Therefore, in my opinion, this is the best alternative, not just alternative. I thank the administrator for giving me an opportunity to express myself about what I felt, and it may be of some help. Thank you.
Thank you very much, sir, for submitting your views and experiences before time. May I now request Pratik Datta to present his research work? Yeah, please.
The presentation. Can the presentation be put up? Yeah. Hello, good morning to all of you. I'm Pratik Datta. I work for a think tank of the Ministry of Finance in Delhi. Today, what I'm going to present is a paper that we are working with the Indian Statistical Institute and Daksh. Surya from Daksh is a co-author of this paper. It's about calculating the quantitative performance of the Income Tax Appellate Tribunal. We are adding some novelty to the present literature on this subject as far as calculating judicial delays are concerned, and I'll explain you why. To start off with just some context, right? So we keep on talking about backlog, pendency, etc., as if these are problems that have just cropped up and these are serious problems today. Actually, it's not. It's been happening since there's a specific report in 1793 when Lord Cornwallis also was bothered about a huge backlog in the courts in British India in 1793. So this is not a new phenomenon at all, right? So we are trying to solve something that a lot of intellectuals across space and time have tried to solve. Therefore, we need to really rethink the way these problems need to be addressed, right? So one common remedy that has been suggested across is that we should increase the number of judges. But how many judges do we exactly need to solve this problem of backlog and delay? Well, there are a lot of suggestions, but most of the suggestions do not seem to come out of any rational scientific basis. And that's exactly what the Supreme Court in 2012 in the Imtiaz Ahmed's case observed, and told the Law Commission that, you know what, please go back and check what are the scientific methods of calculating what exactly should be the number of judges required in India to clear the problem of backlog of the past and to prevent backlog in the future. And they came up, the Law Commission basically spoke about in this 2014 report, it talks about 4 models, right? So the first is the judge to population ratio. You see this statistic being used a lot, that there has to be 10 judges per million of population, or 100 judges per million of population, etc., etc. The Law Commission, mind you, rejected this, this statistic, because they said that, depending on the economic situation of a society or social and political considerations, the number of judges may vary. And that's perfectly fine. So this is not a good statistic. So they rejected it. The second is the ideal caseload method. So again, this is also a statistic that is quite often used, that one judge should handle around 10 cases a month. But again, I mean, cases are of different types of cases may have different factual scenarios. So even this test was rejected by the Law Commission. The third one was the time-based method, where basically you calculate how much time is taken to dispose of a case of a particular type, and how much time is available with the judges that you have, and you divide the number of, the time a judge takes to dispose of a case with the total amount of time required to dispose of all the cases, and you get the number of judges. But the problem, the Law Commission said this is a great method, but we don't have enough data about how much time a judge takes to dispose of different types of cases. Therefore, this method was also rejected. So what the Law Commission finally agreed on was the rate of disposal method. So let's understand what this rate of disposal method is, and on this basis, I'll explain what exactly our paper is trying to do. So essentially, what the Law Commission observed, that if, say, today, if you are to reform the way the Karnataka Appellate Tribunal functions, then there's already a backlog of cases, right, that is already pending. And there will be cases that will come up in the future. So the Law Commission divided this 2 parts separately. So they said that you need to calculate how many judges are required to resolve the pending cases within the next X number of years. That's a separate chunk. And going ahead in the future, you want the rate of institution of fresh cases to be equal to or not more than the rate of disposal, right? So if 10 cases are filed in the next month, 10 cases should also get disposed of, right? Or maybe 15 cases should get disposed of. But the thing is, the rate of institution must not be greater than the rate of disposal, right? So to maintain that, how many judges would you need for the future? So these are the broad 2 components of the RODM method. Now, there's one problem, however, with this method. So let's assume, so I'm not talking about the first part, okay? So there's a backlog, you calculate how many judges are required to clear that backlog. But going ahead in the future, say this month, 10 cases are filed and 10 cases are also disposed of, right? So the 10 cases that are disposed of need not necessarily be the 10 cases that are also filed in the month. Now, we do not know whether the 10 cases that got disposed of have been pending for the last 20 years, last 10 years, last 5 years, or the last 1 year, right? So just because you have a great disposal rate does not mean you have solved the problem of judicial delay. So this is a flaw of this method. So just because your rate of institution is equal to the rate of disposition does not necessarily mean that you have solved the problem of judicial delay, because the 10 cases that you are disposing of today may have been pending for the last 20 years, and therefore the problem of judicial delay still remains. So this is where we come in and we provide a way of solving this problem, at least if not solving, but analyzing this problem better. So what we refer to this is the lifespan of a case. So if you use the RODM method, you know how many cases got disposed of this month or in a year. But what you do not know is what was the lifespan of each of the cases that got disposed of this year. So what we are focusing on in this study is the lifespan of a case and not just disposal of cases. And so we are basically adding three things. One, the Law Commission said that they could not study the courts from a time-based model because of data limitations. So we have avoided this problem of data limitation because we are not depending on any reporting by any court. We are creating our data set. So our proposition is that if the cause lists of any court is available online in a PDF format, we are able to extract data out of those cause lists and make our own data set. So we do not need any of the reporting done by any courts. Now, this is a problem that we face in India because courts and tribunals have extremely bad reporting systems, and ideally this should be resolved. But given the pathetic statistical disposition by courts and tribunals, this is a way in which you can still calculate the functioning of courts and tribunals without having to depend on their data sets, right? The second novel statistics that we are using is called Kaplan-Meier survival curve. Now, this is a statistical model that is used in medical literature to determine the efficiency of a treatment, and I'll explain you that. And we are using it for the first time to study the problem of judicial delay. In fact, there are, to my understanding, only 2 papers which apply it to the legal literature in patents, but no one really has used this statistics to solve the problem of judicial delay. And the third novelty of this paper is you can use this method, the statistical method, to determine the effectiveness of any software or any reform intervention that you make to the judiciary. So for example, a lot of times people say that adding more judges will solve the problem of delay. Will it? Well, what this method can do is after the appointment of judges, this method can actually see whether the appointment of more judges actually solves delay. Because there's an interesting paper of 1989 by Priest, which says that appointing judges do not solve judicial delay. In fact, what he argues is that if you appoint more judges, your caseload will go down, your pendency will go down, therefore the economic value of a litigation will go up. And that's where more people will start filing litigation. So if you appoint more judges, more people will file litigation and you will go back to the constant pendency that you earlier had. So this is called the dynamic pendency problem, right? And there's a lot of literature on this, that appointment of judges do not solve pendency, right? So this solution of appointing of judges, whether in the Indian scenario it can solve the problem or not, we can test by this method. Now with that, I go into the lifespan analysis, right? So as I said, this method is used mainly in medical literature, to some extent even in criminology. Now let me give you a simple example to understand how this method is being used in medical literature. So let's assume there are 200 people suffering from similar type of cancer, okay? Now there are 2 treatments available to treat that cancer. The question is which treatment is better than the other, right? How do you test that? You divide this 200 people into 2 groups of 100 each, right? The first group of 100 people, you put them under treatment A. And the second group of 100 people, you put them under treatment B, right? And what you see is what is the probability of survival of individuals in both groups who are undergoing different treatments. Now, I will use that a bit later to give you. Okay, so this is the curve, right? So on the y-axis, there is proportion surviving. On the x-axis, there's number of years. Now, as you see, there are 2 treatments, right? Can you guess which treatment is better than the other? So treatment A, at the end of 2 years, the proportion of people surviving who were undergoing treatment A is more than 0.5. So more than half of the people in the group are surviving at the end of year 2. Whereas people who underwent treatment B, less than half of that group survived after year 2, right? So this means that treatment A is better than treatment B, right? So the same logic can be used to study a judicial problem where basically the survival would mean the probability of non-disposal of a case. So in case of medical literature, you're treating a patient to save his life, right? To make sure that the patient survives. In case of a court, you're treating a case for the exactly opposite reason, because you want to kill the case, because you want to dispose of the case, right? So the treatments are different, the purpose of the treatments are different, but the usage of the statistical tool is the same, right? So the question that we need to ask is, how many cases survive or that do not get disposed of after 6 months, after 1 year, after 2 years, right? That's the question that we need to ask. And we can then compare whether two different branches of the tribunal, one is using software A and the other is using software B, whether software A gives a better result than software B. This is how we can actually test whether all these judicial reforms are effective in real life. Now, the survival probability is calculated as the total number of cases completed at the end of the time period T divided by the total number of cases at the beginning of time period T. That gives you the survival probability. And this gives you a measure of the time of completion of the case. Now, one advantage that this method gives is that, let's go back to the medical science example, right? Just because you are carrying on your experiment over 100 patients do not mean that the 100 patients will cooperate with you over the lifespan of the experiment. So say the experiment goes on for 3 years. Now, 2 of the patients might leave on the first year, 3 patients may leave on the second year, and 4 patients may leave on the third year, right? So this statistics of this 10, 11 patients, you need to take it out, right? In a survival analysis, because you have the details of each patient uniquely identified, you can remove those data statistics from this study, right? So similarly, for our study also, because we are using the survival curve, we can do that, and that gives you a much better estimate of judicial delay. So the example that we are using is from ITAT, which just completed 75 years. Surya from Daksh has been studying this, so he will, if you want. No, it's not on. Yeah.
Just a minute on how we got the data to show that getting data on tribunals or courts is not easy. We had to go to the website of each bench of the Income Tax Appellate Tribunal, download the cause list for each day, put that together into one database, have a programmer make sure that it it's usable for data analysis purposes. More importantly, because cause lists don't give disposal dates, we had to go into a public database called India Kanun, which lists all the judgments. That is a very textual file. Pull that out, and from the text of the judgment, pull out the date of pronouncement or the date of judgment, again in various different formats. It would be so much better if all of this comes from the courts or the tribunals themselves. I'm sure we will see more progress on that, but just to share the hardship that we had to go through to put together this data set. Go on, Pratik.
So we collected around 2.5 lakh listing data points from around 60,000 cases. So all this thing was done from the cause lists of the data. However, for the purpose of this study, I'll confine myself to the ITAT benches of Bombay and Delhi. Although we have data from 6 other benches, but we will confine ourselves only to this because the Delhi and Bombay benches together constitute 51% of the ITAT caseload. So the interesting data that we have got is that on average, every day, there are 135 listings in Bombay as against 165 listings in Delhi. The number of benches are the same. Both Bombay and Delhi have 14 benches, right? So the number of judges are the same. Yet the disposal rates are completely opposite. So Bombay, which has lesser listings, have higher disposal rate of 10, whereas Delhi, which have a higher listing, has a lesser disposal rate of 4.25, right? These are the types of orders. So as you see, most of the orders are on IT assessment orders. This is just to give you a flavor of what kind of different cases we are studying. So this is this statistics is showing us in the year 2013, the cases that got listed for the first time in 2013, out of them, in the next 3 years, up to 2016, only 0.22% of the cases got disposed of. The rest, 78, were pending in the system. Now with this, let's come to the survival curve, right? So what the survival curve is showing us is that the blue line is Delhi and the green line is Bombay. So it shows us that even though both the benches have the same number of judges, after the end of 3.5 years, there's a probability that 60% of the case, there's a 60% probability that a case would not be resolved in Bombay. But there's a 80% probability that a case in Delhi will not get resolved, right? So remember, these are the, both Bombay and Delhi have the same judge strength, right? So the judge strength is the same. Is the same tribunal, is getting similar matters, yet the outcome is very different. Now, it could be because judges work differently. It could be because the administration of the tribunals are work differently. It could be because of various other reasons. But at least this shows you, this gives you a realistic estimate of what is going across the different benches of the ITAT. So while the Delhi bench seems to be far more efficient, the Bombay bench is not as efficient, right? This survival curve shows you the time taken for different kinds of matter. So we saw that there are 5 different kinds of matter. And now if you see, the orange line is on the assessment of searched persons. So what it shows is that the probability of an assessment of searched person cases getting resolved is far higher than the probability of, say, a assessment after draft assessment order. So this kind of granularity gives you more clarity as to in what kind of cases you need to put more judges or you need to allocate more resources. Now, without this kind of data set, you can't really counter the problem of judicial delay, because judicial delay is today not even being calculated. What we are calculating is a disposal rate, which does not give you any sense of this level of granularity. Now, this is just to give a sense of the study that we are doing and to set the context for today's discussion, because it's a discussion on use of quantitative methods to analyze tribunal performances. But with that, I just wanted to mention the way forward would be, one, as Surya mentioned, we need the tribunals and the courts to release much better data sets. Today, that's not happening. Second is, even after this kind of study, it is difficult to say what is the exact reason, although the tribunals have the same number of judges, what is the reason why the outcomes are so different? Now, this may depend on the type of cases, on the type of entity, so whether it's an individual or a company that is filing the matter, what kind of case it is. It can depend on the number of judges. We are not denying that. We don't know whether that is the only factor. The point being that these are all important questions, and to resolve them, we need empirical proof, and we need to use the right statistical model. So going ahead, if tribunals release better data sets, we can do much more scientific study and make much better policy analysis as to how the tribunals can perform better. Now, with that, I will end my talk. Thank you. Thanks a lot.
Thank you, Pratik, very much, because no doubt the qualitative analysis of tribunals and appellate authority is important, but at the same time, we need to know the facts and figures, especially comparing, different tribunals and appellate authorities, and that will, give us a sense what are the ways to strengthen these tribunals, and where we need a resource is not just only about human resource, but also financial resource and scientific and technical details. Hope this will, create more debate and, discussion during the open discussion time. Now I request Professor Sudhir to present his study.
Thanks Geetanjoy, and good morning once again. So I have 15 minutes and I have a long slide deck, so I'm going to get straight to work. Pratik has already taken us through problems related to access to data, and I want to just approach that same problem in a slightly different way. See that there is public access to court data, but this data is usually in an aggregate basis in the annual reports of various courts and tribunals. This is not really useful, at least for academic analysis and understanding of what are the institutional reform issues that we need to drive in these institutions. Ironically, there's been a big push for the release of data in all these institutions and tribunals and courts. But there is a strange tweak. It's very similar to what executive government is doing, which is that we are very interested in sharing user-friendly data, by which I mean a sort of consumer-centric release of data strategy. My litigant needs to know, my litigant needs to get SMSs about when their case is coming up. And this seems to be a big drive in this direction. And I think the upshot of what Pratik said and Surya mentioned about IT-80 data is we need open access to data. These are public institutions run on taxpayer money. There is absolutely no reason why the public should not have access to all the data that is available in these institutions at the level of granularity that allows understanding. It's not just consumers and users of the system who need access to this data, it's every citizen of the country. Anyone who wants access to the data should be able to get it on standard APIs and data formats that anyone can use and analyze. This is a very big problem. There's only one way to get around it, and this paper relies on that strategy, which is that when courts or tribunals allow access, official access, then we get access to this granular data. And thanks to the chairman, the KAT, and the registrar and her team, we have got access to this data, which is why we can present this paper today. The paper does not focus on making some new theoretical claim or applying a new statistical model like Pratik is doing. It's much more preliminary. It's just 8 weeks in the making. So it still tells us interesting, it probably offers us some interesting new insights on what's going on in the tribunal. The first thing I want to say is that clearly there are many people in this room who've worked in the tribunal and on the tribunal far longer than I have, and I am most willing to learn and hope to hear back from you on the data that we present and ask us questions and provide us answers to the questions we have. So we said something about quantitative analysis. We also said something about evaluating tribunals. And I think this is important. That's the topic of this session. How do you evaluate tribunals? And one way of doing it is simply to take a tribunal to be a court. I think Pratik's doing that. You'll notice in my slides that we too do that. We essentially focus on the standard metrics of analyzing a court: disposal rates, filing rates, clearance rates, congestion rates, and so on and so forth. We can slap on other analytical and statistical models onto the analysis, but essentially we're looking at it as a court. This is a viable way of looking at tribunals, but maybe we should think about that question a little more carefully. Should they be looked at only as courts? The second option is what Mr. Arvind Jadhav spoke about at the end of the day yesterday. He said, why don't you look at tribunals not just as courts, but as institutions that are meant to reshape administrative practice? In that case, a good tribunal is a tribunal that makes for better administrative decision making. So really what we are not concerned, the primary model of analysis need not be just disposal rates. It can be substantive impact. Does it change the way revenue commissioners conduct land acquisition proceedings? This would make a difference. And this is a more substantive and yet quantitative model of analysis, and it doesn't treat the court merely as a tribunal. This is worth doing. I can't think of a single study that has done it, but maybe we should start thinking like that. I think yesterday, Geetanjoy in his presentation on the NGT tried to alert us to some of that, trying to look at the NGT and its impact on environmental decision making. And this might be a useful way of thinking about the question of how do you evaluate? What are the parameters? Having said that, in this presentation, I've stuck to a court-based parameters model, and let me just share with you what we have found at the end of 8 weeks. I just need the clicker. So let's get started. So if you start with the, just a word, maybe I'll do my acknowledgements at the end. So let's just start with the overall statistics as reported by the Karnataka Appellate Tribunal. If you take a close look at that, this is the official records. I've not put 2016 on it. I got access to 2016 data 2 days ago, but the data does not change the trend. Notice two important things. First, that the rate of filing is decreasing. The rate of disposal is increasing. In 2016, the rate of filing continues to decrease. rather precipitously down to something like just 1,500, 1,700 matters. And the rate of disposal increases up to 2015, but in 2016 it drops. And I say this with caution in two ways. If you break down the subject matter of filing, you notice that the drop is driven by the cooperatives cases. And there might be a simple doctrinal reason or a legislative amendment reason why the filing rate drops, but it's significant nevertheless. It may not be an overall indicator of demand for tribunal services, but insofar as we run successful institutions, the fact that citizens actually come to these institutions is some indicator of success. And we might want to think about why, while the overall disposal rate, sort of counterintuitive to what Pratik said, generally when disposal rates go up, filing rates go up. That is true, empirically true across most legal systems. But in the case of KAT, we see an increase in disposal rate and a decrease in filing rate. I'll leave it at that. I'll say a little more as we go along. So we can break this down and look at it by each year and look at the nature of the docket. And it's so small that I can barely read it, so maybe I turn back. So in the orange, you have revenue cases. In the yellow, I'll just call it yellow, cooperative cases, and green sales tax cases. And you notice that the docket is dominated by revenue and sales tax cases with a smaller number of cooperative cases. And the trend lines suggest that that is only accentuated with each passing year. If you look at disposals, you'll notice that cooperative disposals are extremely high. It might be a function of the lower docket size, or it might be a function of the nature of the matters. But generally speaking, you will see a higher range in the cooperative side. I'm going to rush through my slides a little bit. Be glad to share these slides with anyone who wants. Don't rush through the slides. So we look at two standard metrics for thinking about how any court-type institution is performing. We want to look at clearance rates and we want to look at congestion rates. Now these are measures which just to be clear, these are measures that are used in the academic legal literature on court analysis. I'm not going to suggest and defend any of these measures at the moment, but generally speaking, you're trying to increase your clearance rates and reduce your congestion rates. That's the kind of statistic that you're looking for. In the two bar graphs that you see up, we have broken it down by subject matter. And this is to Pratik's point that unless you break down a court's docket or a tribunal's docket carefully by subject matter, presenting aggregate statistics is not useful. Right? We want to know what kinds of cases, and really, you'll notice when I get to my last slides, even within sales tax cases, we want to know what kinds of sales tax cases show particular features of disposal rates, because it's only at that level of granularity that we can develop some predictive power. A second metric that we use in thinking about the usefulness, and here we're really talking about a tribunal, is to think in terms of its appeal and reversal rate, right? So essentially the view you can take, the sort of normative view you can take, is that an institution is a good institution when it decides cases quickly and those cases stay decided. If those cases are simply fodder and work through the chain of the appeal system or the review system and get reversed at higher levels, quick disposal rates are neither here nor there. What's important in a tribunal or a court's functioning is dispute settlement. The dispute should end. Now, measuring appeals and reversal rate in the High Court is very difficult for the Karnataka Appellate Tribunal, and there's a reason for this. There are three possible statistical data sets that we can work with. One is that the High Court calls for records from the KAT. When we look at the call for records data, it's abysmal. There are very, very few cases recorded it's less than 100 from what I remember. But that's clearly not all the cases that are going to the High Court. So we used another method, which is similar to what Surya spoke about. We went to the databases and looked at, we used a 3-year period, and we said if 2014 cases, X number of cases are decided in 2014, let's take 3 years and see how many of these cases end up being decided by the High Court. Remember, we took decided by the High Court, not filed before the High Court, because the High Court's database is not available to us. So we have no way of understanding how many KAT cases have been filed in the High Court. When we look at the disposal rate, the number of cases that go into the High Court and are decided by the High Court, the number looks like about 700, which is still a reasonably low rate. So if the metric, if the measure of tribunal success is appeals, reviews, and reversals in the higher courts, we're not looking at reversal because we have not analyzed in the 700 cases how many cases have gone, has the court reversed the KAT decision. We have not done that analysis yet. But even if we take the appeal rate is less than 20%. And if that is the case, if this number is reliable, we need to validate it a little more. It's a good number to have for any tribunal or institution. So there is now we start opening up the some Pandora's boxes for thinking about how data gets generated, because you'll notice something quite stark in the graphs if you break them up year-wise. We studied 2 years. We studied 2014 and we studied 2016. The striking statistic that you get is that when we look at overall monthly filings, there seems to be a sort of December itch. In December, parties seem to decide that they need to come to the KAT. Now clearly, there's something wrong. There is nothing in the month of December that should lead to the increase in filings. So there's something going on in the recording practices in the tribunal that generate the statistic. As I work through the slides, you'll see that this is a persistent feature of the database maintained. I'm talking about paper registers that we have generated an electronic database from. Overall monthly disposal shows the same kind of number. And if we break it down by subject matter, the same thing. Revenue disposals, cooperative societies disposals, sales tax filings, sales tax disposals. So this is a remarkably resilient sort of number to suggest that there's something clearly in the way the tribunal works that December seems to be, November and December probably seem to be months of great activity. I'm sure there are good administrative explanations for this, but it would be interesting to hear them. So we've looked, what have we looked at so far? I'm moving into the 2016 database. My time's up. I'm going to take 5 more minutes to just talk about 2016. So in 2014, just to take you through the 2 years that we have studied, in 2014, we studied every case, every single case that came through the KAT. Every case that was filed, we tracked it through. In 2016, we developed a sample. What we changed our attention. We were not looking at filing rates and disposal rates and by court hall. We were very interested in looking in 2016 at case flow. Our focus was on, in 2016, if we look at the disposed cases, what kind of characteristics do they have? This is similar to some of the questions that Pratik was asking. So we used a sample set. We took the 3 main jurisdictions, and we took 6 cases from each jurisdiction. We randomized it across, every 2 months, taking cases across every 2 months. This is a standard randomization strategy to develop a sample. Many studies of courts around the world use the same randomization strategy. If there should be no particular difference to the first case disposed of each month, there should be no particular preference rather or bias. So the randomization the randomization strategy should work. As to what the sample size should be is a little bit that we can argue about. Should it be 18 cases? Should it be some other number? Is worth thinking about. We just went with 18 as much to optimize the time that we had on hand. The question that we wanted to ask very different in 2016. We didn't want to just look at appeal rates, and we didn't want to just look at filing rates and disposal rates. We wanted to look at the process. What do we learn about the process in the KAT when we look at disposed cases, most recently disposed cases? And arguably we can say something about why some cases take more time than another, but I'm not going to venture in that direction today because I don't think we know enough. This tells us something about the randomization strategy. We also paid attention to court halls, so we randomized across the court halls in a consistent way. So I'm not going to take you through those details. Let's see what we find. In 2016, we find that, and just, I don't know if you're able to see, it's probably quite small. On the left-hand side, the bar graph on the left-hand side, the blue column are cases before 2010. In the orange column are cases between 2010 and 2013. And in the gray column are cases between 2013 and 2015. So of the cases disposed, the large majority of cases in our sample were recent cases. So this can be an indicator, a healthy indicator, in that why do we use the 3-year limit? For the same reason that Pratik used it, and the same reason that the Law Commission and the Supreme Court of India uses it. They have come up with a normative number that if cases are disposed within 3 years, they should not count in your delay statistics. So we just use 2013 to 15 as the number. So a good majority of cases disposed by the KAT in 2016 are cases that come within the 3-year limit. So that's one healthy sign about, what is it? It's more than 50%. When we break it down by subject matter type, we notice greater variation. So this is important. You notice that in some subject matters, the cases disposed are slightly older, and in other subject matters, the cases disposed are newer. And paying attention to this subject matter question is a really important way to try and understand delay. So I'm just going to run through my next 3 slides quickly. We then broke up the process time in each subject matter type case and averaged it across the cases that we sampled. And what we find is very interesting, that if you look on the right-hand side, if you want to, I'm just going to broadly describe this. You can look at the details later, but if you look at what's on the right, all of that happens before arguments. So the process that the case takes between your filing, curing of defects, your, just the case is simply not put up. There are all sorts of adjournments, early adjournments. In some cases, there are interim order phases and so on and so forth, or hearings, is more than 60% across the board. And if I move across the co-op and into sales tax, you start inching towards 70%. And this is what would be called, at least in British legal reform parlance, non-effective hearings. This is the kind of work that in Britain, in the Wolf reforms, were completely transferred as being registry functions. No court sitting in court ever did any of these things. Notice, issuing of notice, calling for records, that kind of time period, entirely pushed out of the courtroom into the registry process, given very tight time frames to get done. You'll notice that if we move into the revenue process, it is the worst. Of the 3, between co-op and sales tax and revenue, it's a kind of an increasing scale. In the co-op cases, less time is used in the procedural formalities before any actual effective hearing takes place. It's more in the case of sales tax, and it's incredible in the case of the revenue department, because in some cases we found that more than 1,200 days had been spent before the records even showed up in court, and the case had been in the KT for a very long time. We also studied outcomes in this sample set. We wanted to study who wins. Is the state winning? Are private parties winning? Are the applicants winning or the respondents winning? And what's interesting here is that the number of cases that were dismissed, there's a very different win-loss statistic across the subject matter. And again, this requires further investigation and understanding, but simply put, the number of cases that more often than not, let me do overall, which is, no, I don't have an overall on this. On the revenue side, the number of cases that are allowed are higher than in any other subcategory of cases. And in the co-op cases, the number of cases where the person coming to the court loses is much higher than in the other cases. And this is something that we must think about. I think that's about the last slide. Yes. So let me just say one thing. I don't know if I get back to the beginning. So data work takes a lot of effort from various, yeah, thanks. I just wanted the opening slide. So this is no different. Three of our students, Aradhana, Harshal, and Sachin, helped code the data sets. Apurv helped at the early stage of putting it together. Amulya stayed with the study right to the slides that you see before you. This is very preliminary results. We need to deep dive into many of these questions and data numbers before we both understand them and offer deeper insight and solutions. So let me stop there and pass it back to Geetanjoy. Thank you.
Okay, thank you very much. All the four speakers highlighted like how and why quantitative analysis of appellate authorities and tribunals are important. And they are important for various reasons. And I see specifically for three important reasons. One is for research and documentation, because unless the data is available or uploaded in respective websites or in their department, whatever online, it's very difficult to analyze what exactly is the impact of these tribunals, especially the process they follow. Second, it is also important for advocacy. Very often there are people who are interested to work in this field, but because of lack of data or information, there is hardly any scope or space to engage with the establishment. And when I say advocacy, ranging from the authorities to civil society groups and various other institutes which are interested to work in this area. Third, it is also important for capacity building. Capacity building of the authorities when you talk about the number of cases pending and why those cases are pending, and when you said the number of cases are resolved in December, number of cases are filed increasing in December, so there must be something one needs to engage with why all the three aspects are happening in a particular month. And this is also true in case of various other appellate authorities where applications are filed in a particular month and resolved in a particular month. So this will be useful to know what are those lacunas which are there in the authorities. Now, when I say this is important both for research, for all three reasons, research, advocacy, and capacity building, I'll just draw your attention to one recent data set. The government of India has come out with this new data set that is called environmental crime. Environmental crime data set was reported by the NCRB 2014. For the first time they came out. And you would be surprised to know in 2014 when they came out with this data set, they identified 5,846 crimes in India. Out of 5,846 crimes, only 50 crimes are related to industrial pollutions. And out of those 50 crimes, 42 crimes are in Maharashtra, and remaining 8 crimes are in 5 southern states. That means all those other 26 states, there was not a single environmental crime. And those other 26 states include those states where you have those critically polluted areas, 41 critically polluted areas. So this shows there is something, there is some serious problem when it comes to how we sort of, feed data in our sort of, recording system and how that goes to different authorities. Because out of those 5,846 cases, again, 77% of cases are registered under the Indian Forest Act and the Wildlife Protection Act. And only 50 cases are under Water Pollution and Prevention Act and all those 100 environmental rules and regulations. So this is very important when we get the data set, and people who are representing different appellate authorities and tribunals, we would urge them to sort of bring this data set, upload in their respective websites, and it will help various institutes, even academic institutes like Azim, Premji and TIS should be happy to engage with this data set and come out with different analysis which can be further discussed and debated. So with this now I open this floor for discussion. We have 15 minutes for discussion. So you please introduce your name and the organization you represent, and also direct the question.
Hello. My good name is V. Munavenkatesh, Assistant Registrar Retired, Karnataka Appellate Tribunal, Bangalore. With my little memory, way back, that is a decade ago, one Mr. V.G. Gujran, commercial tax member, has written a historic order in the tribunal. Probably a department people who are, somebody is here, if they are aware, they can share with me. In his order, a beautiful order he has written. That is, 220 pages he has written at length. For that, a district judge member has given a consent. By way, as he don't want to scratch his head. Because in the sales tax matters, most of the cases, the commercial tax members, they man over the things. The reason is very simple. In a commercial tax cases, the schedules are there, calculations are there, and some other things are there. Assessing authority is there, first appellate authority is there. All these things, the district judge, they don't want to go through all these things. A commercial tax member, he has come from the royal rank as an assistant commissioner, joint commissioner, deputy commissioner, and then he has become the additional commissioner of commercial tax, and sit over on the commercial tax member in Karnataka Appellate Tribunal. Really, he gives a very good shape to the case which he has handled in his lower ranking all along in the department. The department, at the fag end of his order, he writes.
Sir, we have very little time. Can you
just a minute. Yeah. He writes a beautiful sentence. That is, appeal is allowed. That is, L&T versus State of Karnataka. L&T versus State of Karnataka. It involves 2 crores of tax. Fairly writes, appeal is allowed. Why? Because our house is not in order. That is, our house is.
So can you just brief your question?
What I'm telling.
No.
The house is not in order. The house is in not order means the department is not proper. He has sued the department, and he has passed the beautiful order. For that, a district judge member has given the consent. All right, okay.
Thank you very much. It's okay, we'll come back again.
Review has not been filed in that case. Why? The departmental people have not filed the review.
Okay.
That is the thing.
So any more? Yes, sir, please.
G.K. Upadhyay, President, Gujarat Cooperative Tribunal. In data, Right to Information Act is there. But even though common friendly users' data are not available in all the tribunals in India, the grouping and bunching and classification of codes are required for every matter and every subject if you want to achieve anything from tribunals. That's my question. Are we doing or not? We should see in our heart, and after that we can do help to our people.
Okay, sir has a question. Yeah, please. We'll take 5 questions then.
Justice Reddy, a retired judge of the High Court of Karnataka. We've been doing a lot of this work, whatever you have done. But the real question is, when you meant backlog, take a situation. December 2016, a case is filed. Do you mean say it's a backlog in January of 2017? Critically try to analyze it. We can't go by these backlogs. Backlogs are what we think of in terms of hearing, when the cases come up for hearing at a particular date, and if it is not heard, that means when it has finally reached a stage which could constitute something like making of a judgment, nothing happens. And perhaps from that day you can call it a backlog. All these administrative works of trying to get records, trying to issue notices, serving it on parties, hearing interlocutory applications, but these things cannot constitute backlogs at all. There's yet another reason. Backlog is not just backlog as it is because it is pending for many, many years. Do you have the competent officers to man these organizations? Do you have people who have adequacies or inadequacies in their kind of work that they want to do? What's the kind of human resource development or done on this? What's the kind of training that you're giving to all these people? But these are many, many and more issues that arise. But it's nice to hear from all of you today that you have broken the ice. Somewhere you've started making creating a dent into understanding of what's happening in courts to make it more transparent. It's really good. I wish today's opening of this subject would lead to something comprehensive. You must have also known by now that the Supreme Court has constituted a national court management system. Now that is very comprehensive. As a member of that system, I had an occasion to deal with all these issues, which perhaps I will say when my next term comes up. But we've got to think in terms of policy decisions. Policy decisions are very important. Once we do that and keep these policies for the entire country, I don't think many things may arise. But as you rightly said, availability of data is the most important moot question, I would say. And if that is not done, well, nothing is done. Thank you.
We have the speaker.
My name is Mamdapur, Presiding Officer, Labour Courts, Bangalore. My question is, Mr. Sudhir, sir, you have done a lot of research in respect of filing of more cases, filing of less cases, and disposal of more cases. But we have to ascertain the reason why there is less filing. And one more thing is, 4,278 cases were disposed of in 2014 to 2016. And only 20% cases, 761 cases, appeals have been filed. Whether the disposal is on merits, in what way the cases were disposed of, whether reliefs were given or not. That way the research is very important. This is my suggestion, sir. Thank you.
We will take the last question there for this first round. Yeah.
I'm Alok. I'm an advocate in Bangalore and a visiting fellow at the Vidhi Center for Legal Policy. I just had this question regarding Pratik and Surya's research on the IT-80. I just wanted a couple of clarifications based on what you have seen. One was, did you sort of look at how the listing process in the Bombay and Delhi differed? Because although there seems to be approximately the same number of cases, I've started some very preliminary research on the Supreme Court, some along the lines of what you have done. And my first big realization was that listing is a little idiosyncratic. There is no set rule or procedure. It is up to the presiding officer. So sometimes you have the absurdity of 200 cases listed before a judge when there is no possibility of more than 15 being taken up. But they list 200 all the same to make it seem like either they're listing it. So I just wanted to know in what way the cases were listed. Was there a systematic way in which they ordered the cases, were cases ripe for hearing coming up? Just to make sense of the number, of the fact that there's a vast difference in, I'm not talking about a small 10-15% difference. Clearly, Bombay is able to dispose of twice the number of cases on a given day than Delhi. Would that have some linkage to the way in which they list cases? Thank you.
The answer to my KAT former officer's question is, his impression that always the department members took over the decisions in commercial tax. My answer is, as long as I was there for 3 years, not a single member overtook me. This is, and so for not filing the review, this is the matter which must ask the Commissioner of Commercial Tax. Must ask. I have sent about 25 judgments to the Commissioner of Commercial Tax, passing strictures against them. In one review petition, one of the member who was here, when he was taken back to legal cell, he has written such a aspersion on the KAT. I passed strictures and sent the judgment to Commissioner. When you are asking for the review, please pray it. Don't dictate or mandate. And secondly, my friend said that this revenue matter, I told, as a judges were least bothered about the revenue, but about the legality. Reddy structures matter which I have written, worst contract. Everybody was quoting Gyan and Tankerle, rail development. Nobody was analyzing what it is. In that case, what happened, do you know? The assessing officer had given 10% land values exemption. The first appellate has given the 25%. The state has come in appeal before me. Then I said, after reading everything, I said that both orders were illegal. See, one thing I tell you, what has happened there is, the respondent said, sir, please reduce it to 15%. Then I said, no, I am not sitting here to modify or vary the illegal order. I said, I'll write the total judgment reappreciating the evidence as the first appellate court. I wrote that order, it was reversed, and do you know that 6 crore rupees was the amount which the assessee got back, which was illegally recovered. We are not bothered about who is getting legality, because High Court will see whether it is legal or not. These are the things. But administrative lapses takes place not because of us, because of that. And then there is, so for the question is, variation is filing. When I went there, very few sale tax matters were there. And after the VAT was introduced, the members were telling that, no, after VAT, there is very little litigations. We can't expect litigation to crop up, because if there is very hassle-free administration, less filing. That is because of that. Now I think after GST, something more happened. And at that time, we 8 members were posted by the Honorable High Court. The 4 benches, tax benches were functioning, therefore it was reduced. So in my opinion, so for tax and this revenue bench are concerned, I think that cooperation and revenue is concerned, fast track benches could do well because 93, 94 matters pending when I was there. Therefore, this may be because as a fast track judge, I worked for 6 years and I had disposed of 1,000 cases in Karwar. By the time I was transferred, only 6 cases were pending. So for these 2 branches, that could be possible, it could ponder over. Thank you.
So I have a small question. Small question.
So as far as the policy decisions that you spoke about, I think one important issue that was flagged by Sudhir is that we can look at the British tribunal reforms, and that has been extremely useful not only for the purposes of just, as Alok mentioned, about standardizing rules, but also about HR. Human resource is one of the most critical elements of any institution. And so it's important to think about a centralized institution at some level which manages it. So it's interesting, and I think this is something that we are going to discuss in the next panel, so I won't go into it, but it's important to take some kind of an understanding of how the British system has changed on tribunalization, and I think that has a lot of implications for India. Thank you.
So just one second. I think the panelists are just going to respond briefly, and then I don't know what the moderator would like us to do. So I want to respond to 2 different parts that came up in the comments. One about data sources. And Mr. Upadhyay mentioned data sources, Justice Ramon Reddy mentioned data sources as well. And I think what's striking is that there is openness to making more data available, though I'm not sure how much of the High Court data is openly accessible either on the website or otherwise. Having said that, I think there's a second problem that every institution makes data available in its own way. I'm just astounded that every tribunal has its own format, and so does every High Court. So this is clearly not the way to go, and to the extent, and you spoke about NGT cases, so I've studied some of the NGT databases, and I think you'd agree that that doesn't look like the Karnataka Appellate Tribunal databases. So I think one of the first elements of national policy that we need, forget about how we serve notice and what adjournments we give, I think we should have a national policy on how data is stored in the Indian court and tribunal system. And it should be a single policy. There can be no variation on that basis. If we don't do this, we can make very little progress on much of the rest that we want to do. But I want to say a second thing about the point that Justice Ramon Reddy made, which is that it can't be that we just take a month and say that this is pendency or this is delay and backlog. These are normative terms. They're not descriptive terms. And we must agree on what are the norms for pendency and backlog. We might want to say that a cooperative case, 12 months is a norm for disposal. But in a sales tax case, it might be 18 months as a reasonable basis, or something like that. This we need to work out. It needs to be sensitive to the details of each case, but we need to have an understanding of that. But what is striking is that if you didn't do that, you'd end up in a position like China, and I just wanted to say this almost by anecdote and slightly trivial one, that China has the opposite of the KAT's graph figures. Because in China, in December, all the graphs point downwards. Because at the end of the year, there is not a single case pending. Even if the case was filed in November, there is great pressure on the court system to clear its dockets by the end of the year. And this pressure is top-down and clear. And all the courts show a downward graph. So it's almost like, I don't know what the inverse logic in the KAT might be, that all the courts show an upward graph, but it might be worth pondering. But I think the arbitrariness of just setting some absurd idea that everything should be cleared by December is clearly a mistake. We need to bring some sense to these categories of backlog and pendency, otherwise they don't really have any meaning. So let me just say that, there was a question by the President of the Labour Tribunal about disposal, and I think there was a partial answer that we tried to understand how many were merits-based disposals, but we did that on a small sample. So on the database, the 2014 database where we studied appeal rates, we didn't have the basis of decision. So because it was the full universe of cases. But you're right that we should pay attention to on what was the decision in the case, and then whether it was appealable, and then constrict that number to get a realistic figure there. I take that point.
Yeah, please.
I'll just take a couple of minutes to. So, Alok, we did not see any significant trend in how cases are listed. And as you are very well aware, there is so much discretion with the registry in how cases are listed. But one could say that the older cases get listed first. That is something that we can say is a thumb rule that for listing. But just to continue on that listing itself, and the point that Justice Ramohan Reddy sir made on NCMS, and a wonderful institution that got set up in 2012. In 2005, consequent to the Salem Advocates Bar Association ruling, there is this wonderful piece of legislation called Case Flow Management Rules, which are already in place across India. They are there, which says, this is how you segregate between stages. This is how you segregate between subject matter. This is how you list. The Karnataka Case Flow Management Rules are the best in the country. There is a debate. You could debate whether it applies to the KAT, but there is nothing that stops you from adopting it. And that actually gives you a limit on how many cases you can list per day, depending on the stage. Wonderful piece of legislation that all of us should use a lot more and implement in Indeed.
Thank you very much. We are sort of time, so we'll break now. And I thank all these panel members for raising several important questions. So we should give them a round of applause for their interesting observation. Thank you. Sorry, sir, we are already late. We'll come back again discuss. So we'll discuss that during tea.
The inferences, he has to tell about the inferences. Had he taken the capacity of all the benches, for example, commercial tax benches has four benches are there. So actually, all benches will not full work in the entire year. That is also true in case of the cooperative benches and also revenue benches. So had you taken this starting also expensive, your inference is bad. Otherwise, you have to give an introspection of those things.
Sudhir will discuss.
That is very important. I feel so. It is very important as far as your inference is concerned, as far as the success rate or the rate of disposals, rate of pendency, all these things.
Okay, Sudhir will explain that during break time. So thank you very much. Now I request Nafiza Madam to felicitate all the speakers.
Good morning, everyone. I'm John Benedict from E-Governance Department. We have a 30 minutes presentation on